everyone. Sorry for my slightly scratchy voice. I have a 6 and a 3-year-old, so this is just how I sound all the time. Thank you for being here today, and thank you very much to the organizers for having us. Lauren and I are very pleased to be speaking with you today about our article, A Decade of FTC v. Actavis. The reverse payment framework is older, but are courts wiser in applying it? This article is very special to us because Actavis and the cases applying it played a very large role in the first decade of our legal careers. Mine in particular began in 2013, just a couple months after the Actavis decision, and I worked on and observed firsthand the case law that evolved, and that experience gave rise to this idea and this project to do a retrospective of the 10 years of case law under the Actavis decision and what questions remain open and which have been solved slightly, and that's what we're going to talk to you about today. So we're going to start with the background, make sure we're all on the same page about what a reverse payment settlement is and the circuit split that led to the Actavis decision, a little bit about our article and how we came about working through this decade of case law, and then finally the crux of the issue, what legal developments there have been interpreting the Actavis framework from 2013 through 2023. This was a 10-year anniversary article that, took some time to get there, but the analysis stops at 2023. Turn it over to Lauren.
As Jaclyn mentioned, we thought it might be helpful to just take a step back and give you a little bit of background on reverse payments and Actavis. So where do reverse payments come from? Under the Hatch-Waxman Act, a generic drug manufacturer can file a paragraph 4 certification. This means that they're saying that their proposed drug product will not infringe the brand's patent, either because it's invalid, unenforceable, or just otherwise won't be infringed. Once the generic files that paragraph 4 certification, that counts as a technical act of patent infringement. So that does two things. One, the brand can automatically sue for patent infringement, and two, it gives the district court jurisdiction over the case. Like many civil litigations, they end in settlement, and the settlement typically allows the generic to enter the market earlier than patent expiration. Where the reverse payment comes from, where the reverse payment allegation comes from, is that plaintiffs allege that by settling the litigation, the brand has transferred some value to the generic. And this is why it's reverse, because in their allegation, the plaintiff, the brand, is paying the generic, the defendant, when typically a defendant pays a plaintiff to settle litigation. So the reverse payment allegation is plaintiffs alleging that the transfer of value from the brand to the generic induced the generic to stay off the market longer than it otherwise would have, if not for the settlement.
Before I get to the circuit split, we should probably introduce ourselves. I'm Jaclyn Phillips. I'm a partner at White & Case, and this is Lauren Gorab, my colleague who is an associate in the Antitrust group at White & Case, and we wrote this article with our two colleagues who couldn't be here today, but are also antitrust litigation partner and associate at White & Case. So now that I've said that, I was too excited to talk about our article. I'll talk about the circuit split. So of course, there's a reason that this case went to the Supreme Court. In the early 2000s, many of these reverse payment cases had been brought, and there were, on both sides of the split, there were fairly straightforward tests to apply, but very opposite tests. So the Second, 11th, and Federal Circuits applied the scope of the patent test, which basically said that the settlement would be per se lawful unless what was provided to the generic was something that went beyond the restraints imposed by the patent. So for instance, an entry date that was past the expiry date of the patent. In the Third Circuit, in the Cater decision, they went in the other direction and applied the quick look standard and found that a reverse payment would be unlawful if there was presumptively unlawful if there was a transfer of value from the brand to the generic. And then the burden automatically would shift to the generic manufacturer, to the brand and generic manufacturer defendants to show that the settlement had pro-competitive effects. So essentially no burden on the plaintiff to prove anti-competitive effects other than the fact that there was a transfer of value. So that went up to the Supreme Court. Next slide. And to keep things interesting and complicated and keep these cases in the courts, I guess, the Supreme Court took the middle ground and applied the rule of reason test and held that a patent settlement may be unlawful if the payment was large and unexplained and led to anti-competitive effects in the form of delayed generic entry. And that's really the key of what our article looks into. How did courts analyze the rule of reason test in the 10 years post-Actavis? So there were a lot of questions that remained unanswered in the wake of Actavis, or that the court gave perhaps incomplete answers to. And some of these issues, unfortunately, we won't get into today and couldn't get into our article, but they are very interesting, such as how and when you evaluate the merits of the underlying patent. Similar to that, questions about causation. Obviously, there's market power questions as well that the courts deal with. But today, we'll really be focusing on the contours of the rule of reason test. This was a quote in Chief Judge Roberts' dissent, where he said, "Good luck to the district courts to apply this test that the majority had just put in place." So the court said, "We'll leave you to structure the rule of reason like you would in other rule of reason tests in this context." And Justice Roberts perhaps realized that that wasn't going to be as simple as those guidelines might appear to be, and that there were going to be complicated issues and questions in having to wade through what the test means in the real world. So that's where we get into looking into these decisions and whether the district courts did struggle with applying that test.
As Jaclyn mentioned, Actavis has been very important in both of our careers thus far, so we knew we wanted to write something to celebrate the 10-year anniversary. We started with a very in-depth review of all the Actavis cases, all the post-Actavis cases, which was about 30 cases that we reviewed for this article, so a decade of case law. Our analysis involved cataloging what types of reverse payments were alleged, the disposition of the case, whether it made it to trial, which is very few of them, and then several other metrics within those broad categories. We wanted to thoroughly understand the landscape, but also the nuances of what was going on in these district courts around the country, what was working, whether there was consensus developing among the courts, and that's where we started. As I mentioned, plaintiffs have brought about 30 reverse payment cases since Actavis. You can see sort of a burst in the years directly following Actavis from 2013 to 2015, and then thereafter in the rest of the decade, a pretty steady filing of cases. Most of the cases have been brought in California, especially in the Northern District and in the Northeast, and for that reason, most of the post-Actavis case law has developed in the First, Second, Third, and Ninth Circuits. So how have they resolved? Like the underlying patent litigations that they're all about, most of these cases do end in settlement, but 8 have been resolved at the motion to dismiss stage, 1 fully resolved at summary judgment, and 3 have gone to a trial verdict.
And the 3 that have gone to verdict were defense verdicts in those 3 cases, and this 1 summary judgment decision was also resolved in defendant's favor. So what happened in those cases where we do have interim decisions, there's not a lot of dispositive motions that were and that ended the case. So back to Justice Roberts' quote, this is really the crux of the issue. How do courts apply the rule of reason in a reverse payment case? What form can a reverse payment take? What does it mean to be large and unexplained? When do you apply the test of whether a reverse payment is large and unexplained? And these are open questions under Actavis that courts have dealt with the contours of these questions in the past 10 years. Lauren's going to start with the forms that we've seen reverse payments be alleged to have taken in these cases.
So these are the types of transfers of value that I mentioned earlier that plaintiffs have alleged are reverse payments. The first is cash payments. Actually, in the years following Actavis, a few district courts held that only pure cash transfers could constitute a reverse payment under Actavis. The First and the Third Circuits quickly dispelled with that notion, which is why there are so many other examples. The next is no authorized generic provisions. This would be a provision in a settlement agreement whereby the brand would agree not to market its own AG. Plaintiffs have challenged these as a transfer of value. They've also challenged what they call implicit no AG agreements, and the allegation would be the terms of the settlement don't specifically prohibit the brand from marketing an AG, but the other terms of the settlement operate to make it almost certainly likely that the brand wouldn't market their own AG, such as the structure of a royalty rate. Acceleration clauses, I think the FTC pretty recently determined that acceleration clauses were almost uniformly used in patent settlements, and so they're obviously challenged. Plaintiffs also challenge contemporaneous business arrangements, or what they sometimes call side deals. These are agreements entered into by the brand and the generic close in time to the settlement. For example, marketing or supply agreement that plaintiffs challenge as a transfer of value. They've also challenged settlement of unrelated IP litigation, either IP litigation between the same brand and the generic about a different product, or about the same product but in a different jurisdiction. Finally, what's really increased in popularity are overarching scheme claims. Plaintiffs argue that although no individual instance of conduct is itself anti-competitive, when you look at the defendant's conduct as a whole, sort of the amalgamation of conduct, it shows an overarching scheme, and those typically involve multiple defendants, so either multiple brands and or multiple generics.
And before we leave that slide, as you look at the case law evolve, you see these theories evolve. So there was a lot of argument in the earlier days post-Actavis about whether no AG provisions could constitute payment or whether they are just providing the generic, for instance, its 180-day exclusivity that it would have received under the statutory scheme anyway. The case law evolved where it became clear that courts were going to find that a no AG provision could constitute something of value, could be an alleged payment. Now we see cases where there isn't an explicit no AG provision, but plaintiffs have theories, like Lauren said, that based on other provisions in the settlement agreements, such as royalty agreements, there is, an implicit no AG agreement, and then the arguments become, well, what do you need to show that it's an implicit rather than an explicit no AG agreement? So there is evolution in these types of arguments as the cases have gone on and the decisions have become more clear about what courts will find is a properly alleged form of a reverse payment. So these threshold questions, what is large, what is unexplained? So there's the question of what is large and unexplained, and then also the question of whose perspective do we look at it from, and then we'll talk about when do you analyze it in the rule of reason analysis. So the Supreme Court largely left up to the district courts to determine whether an alleged payment is large or unexplained. For large, the Supreme Court gave guidance that a payment is large depending on its size, its scale in relation to the payer's anticipated future litigation costs, its independence from other services for which it might represent payment, and the lack of any other convincing justification. There hasn't been a consensus about what benchmark you use to evaluate large. Defendants have argued that payment should be considered large under Actavis in comparison to the profits that the brand is being alleged to have been protecting when it gave the generic company this alleged payment. Plaintiffs argue for a much lower threshold. Any payment greater than the amount of saved litigation costs have argued to have been large. Courts have allowed both these interpretations of largeness to proceed to a jury, so leaving uncertainty about these kind of very differing views of degrees of largeness. Unexplained has some guidance in Actavis. For instance, a payment can be for litigation expenses, compensation for services, for instance, fair value for a co-promote agreement if you are having a generic give promotion services outside of the settlement context. Is it in line with payments for a service like that? And the court said when there's traditional settlement considerations, there's not the same concern that the patentee is using its monopoly profits to avoid the risk of the patent being invalidated. Some courts have allowed cases to proceed when there's an inference that the payment would only be made to delay generic entry, but some courts, recently the Bisolic case in District Court New York, found that there weren't sufficient claims to show that those payments were unusual and anti-competitive. There must be more pled that they would be inconsistent with a pro-competitive justification. And when it comes to the perspective of what's large and unexplained, the court itself seemed to view the size of the payment as a proxy for the brand's view of patent strength. Most courts have assessed large and unexplained, as we get to step one of the rule of reason. Unexplained was from the brand's perspective, but some courts have also asked the question about whether the payment was large enough for the generic to abandon its challenge. So moving on to step one of the rule of reason, plaintiff's burden to show anti-competitive effects, and how does this work in the context of an antitrust claim? So the burden is on the plaintiffs to show anti-competitive effects of the challenge conduct, and courts have taken different approaches on whether it's plaintiff's burden to show that the payment is both large and unexplained at step one, or just whether it's large, and viewing that unexplained portion as something that goes into the second step of the rule of reason, which is defendant's burden. And, it's our view that that's a misinterpretation of Actavis, that large and unexplained is the threshold showing unexplained is not the same thing as unjustified or pro-competitive justification that defendants would have to show at step two. So moving on to step two, depending on how the court looks at this question, and if it found that the plaintiffs have satisfied their burden to show whether large and unjustified, the burden shifts to defendants to show pro-competitive justifications. So a threshold issue in these cases, like other cases looking at in the rule of reason, is how close does the pro-competitive justification have to be to the challenge conduct? And here, that means, does the nexus of the justification have to be with the reverse payment only, or the settlement as a whole? And some courts have held that explicitly that the entirety of the settlement has to be considered when evaluating pro-competitive justifications. So some justifications that have emerged, obviously, early entry. The court held that a justification can't be just to avoid the patent being invalidated, but you can look at the earlier entry of the generic than what would have happened absent the settlement. Other more holistic pro-competitive justifications that have emerged is companies' risk aversion, avoiding distraction and expense to the company, and business certainty. Some of these and a lot of other issues that have come up lead to a lot of other complicated legal questions, such as how you evaluate these and what evidence you look at when you're evaluating these questions, which leads to very, very complicated questions and arguments about privilege and looking at objective versus subjective evidence to evaluate these issues. And maybe that's another article for how that's developed over the past 10 years, but a really interesting legal issue that's popped up in these cases.
And then finally, step three, plaintiffs must show that the pro-competitive justifications could have been achieved in a less restrictive manner. Some courts actually also apply a step four, where they weigh the anti-competitive effects and the pro-competitive justifications to determine whether the plaintiffs have met their burden. Because so few cases get to steps 3 and 4, how to apply this less restrictive alternatives framework in step 3 and 4 is undeveloped.
So that's the summary of it. I think you see that a lot of questions, important questions, are left open with very differing analyses. The question of if something is large in comparison to saved litigation costs from a patent litigation, or large in comparison to, protected monopoly profits is a very different question, and perhaps leads to a lot of different risk when you're considering taking a case to a jury, and those threshold questions remain unanswered. So here's our disclaimer. I guess I'm also supposed to say it out loud, that these are our views, not necessarily the views of our firm or our clients. I'm not good at these formality things, but there you go. And we're almost right on time, so I think David will come up to discuss the article. Thank you.
So the authors have done a really thorough job of summarizing the legal history of these reverse payment cases since the Actavis decision in 2013, including areas that are settled and areas that are less settled. I think this paper will be a very useful guide, for example, for lawyers unfamiliar with these sorts of cases, as well as for more seasoned lawyers wanting to get a deeper understanding of some of the nuances and complexities of these cases. So I'm going to focus on sort of the economic perspective here. I want to highlight several learnings based on working on several of these cases actually through the years myself. We conducted a number of economic analyses related to liability and damages on several of these cases. And actually based on the work that we did, I published a co-authored paper specifically on these cases. It was how to think about the split of the surplus profits between the brand and generic companies in the unobserved, hypothesized entry date only settlement. So let's start with the large and unexplained aspect of these cases that's necessary to qualify as a reverse payment. To be clear, we're talking about the net flow of value, as the speakers mentioned, the net flow of value or payment from the brand to the generic company. And so large doesn't really mean anything without scaling. For example, we might think of large as in terms of a percentage of something. Actavis mentions kind of a laundry list of attributes for large and considers scale only in relation to the payer's expected future litigation costs. So, of course, the word large doesn't really mean anything in the field of economics, or at least not that I'm aware of. But in the reverse payments context, large might mean large enough to, at least in theory, meaningfully move the generic entry date by at least several months, let's say, or put differently, it should correspond to a non-trivial share of at least several months of the difference between the profits without generic competition and the profits with generic competition. The rationale here is that that difference represents the extra profits from generic delay that is allegedly split between the brand and generic companies. So the generic should receive a non-trivial share of those extra profits in order to be willing to delay its entry. Because it may be difficult, though, to estimate the difference between profits without and with generic competition, potential alternatives could be to estimate the brand's profits before or after generic entry, as available, and require that the estimated alleged reverse payment be at least, let's say, 5 to 10% of several months of such estimated profits. Again, I mean, the idea here is to try to scale, come up with a way to think about what size is large enough by scaling it in terms of maybe, as I said, like a 5 to 10% of several months of such estimated profits, because the idea is it has to be large enough to be kind of credible as an incentive for the generic to be willing to delay its entry. I mean, that's basically the core theory of these cases. So unexplained or unjustified basically means that there's a net flow of value of payment from the brand to the generic company without any corresponding benefits in return. As economists, we're generally skeptical about such payments because, of course, there's no such thing as a free lunch. We always tell people. That is, we generally do not expect a party in a negotiation to get something of potentially high value for free. And then another key issue that comes up here is at what point in time should we be assessing whether there was a large and unexplained payment? Should it be when the parties ink the settlement agreement or shortly thereafter? Or should it be at a later point in time when much more information will be revealed about the relative values of different aspects of the settlement? So a common alleged payment in these types of cases, as you guys mentioned, is a promise by the brand not to launch an authorized generic, a so-called no AG promise. But there are a number of complexities when considering whether a no AG promise constitutes a payment. And these have come up in some of the work we've done in these cases. First, the plaintiffs often assume that without any basis that the brand would launch an AG for sure. They basically assume 100% certainty that an AG would be launched, absent the settlement. However, empirical research has shown that it's something on the order of 50%. That is how often the branded company launches or as a third party handle the launch of an AG. So it's nowhere near 100% according to the literature. And so given that an AG is not always expected to be launched, perhaps a more accurate way to estimate the value of a no AG promise is to weight the estimated value of it by the likelihood of the launch actually happening. So on the other hand, though, while plaintiffs might assume 100% launch probability of an AG, the defendants often will claim that they did not plan to launch an AG at all. They're basically saying 0% chance of an AG launch. And therefore, the no AG promise was worth nothing in terms of value transferred from the brand to the generic, basically the branded company saying it didn't give anything up. Again, the literature can be very helpful here. As I said, one article found about a 50% chance of launching an AG. Also, the company's internal documents often can be super helpful here because they'll talk about their own plans, and they may forecast certain contingencies, and those you could have a situation where one plan is what happens if we launch an AG, and then another plan is, wait, maybe we won't launch an AG, we'll do more what might be called a branded as generic strategy. That is, we can use our branded product and have it act like an AG in certain ways. So again, documents, empirical research can be very helpful here. So even putting those issues aside, the valuation of a no AG promise is very complex. So for example, the value to the generic of not facing competition from an AG is the extra profits earned without an AG competitor. Those profits will be impacted by a number of factors, including, for example, how quickly the AG and the regular generic take sales away from the brand over time, how the AG and the regular generic split total generic sales, that is the share of sales, and how the absence of an AG impacts the regular generic's pricing. In some instances in these cases, generic entry has already occurred at the time of the antitrust lawsuit or close in time to the antitrust lawsuit, and so a great deal of information becomes known about sales, prices, shares, and profits of the brand and generic competitor over time. But in some instances, generic entry has not occurred yet, so many assumptions are necessary for some of those variables, those assumptions are often informed by the literature. There have been a lot of studies like what happens when a generic enters in terms of share and pricing. The company's documents often have models and forecasts that can be very useful here. So another consideration is, and this was alluded to by Jaclyn and, sorry, I forgot your, Lauren, sorry, I'm so bad with names. I could never be a politician. But another consideration is whether the settlement, often as part of the no AG promise, includes a royalty payment flowing back to the brand. So, you might think, oh, the no AG has value flowing from the branded company to the generic, but if it's true that there's a royalty provision where the generic pays a royalty back to the branded company, you would want to take into account, sort of do a net net balancing of those flows going in both directions. So I want to just briefly mention another type of alleged payment in these types of cases is the supply of free product from the brand to the generic. So the provision of free product to the generic would seem to clearly be a flow of value from the brand to the generic, but valuing it can be complex. Is it the sales revenue the generic has or would be expected to obtain from selling the free branded product? So sales revenue would be the measure. If so, and if such sales of the generic haven't occurred yet, what would the price be given that the brand and generic would be competing? Or should it be the difference in profits from selling the free branded product compared to the profits from selling the generic product, which is what would likely have occurred absent the provision of the free product? So just wanted to, what I'm talking with free product and the no AG, I'm just kind of going through some of the complexities that come up and just trying to value these aspects of some settlements. So sort of the last big piece here is I just want to briefly talk about the next step here, the next phase. And so the plaintiffs may or may not be successful in demonstrating that there was a large or perhaps unexplained reverse payment, but assuming they are successful in showing that, the defendants have the opportunity to articulate the pro-competitive justifications of the agreement. So in the Opana ER case, for example, which is one of only 3 cases that have gone to a jury verdict, it presents a useful example of how juries may weigh the evidence in these sorts of cases. Because again, it's only one of 3 that has gone to a jury verdict, so it's a good example to think about for those to get kind of insights to how juries think about all the evidence in these cases. So the jury in that case found that the defendants possessed market power and that the settlement contained a reverse payment. However, they also found that the settlement agreement between Endo and Impacts did not violate the Sherman Act. So the key to the jury's decision was that the patent settlement agreement allowed the generic manufacturer to enter with a broad license that allowed the generic to remain in the market for 9 years while courts enforced subsequent patents covering Opana against all the other proposed generics, and that the anti-competitive effects did not outweigh the pro-competitive justifications. So the jury apparently did this balancing and found out that and concluded that the pro-competitive effects seemed significant and sufficient to counterbalance the potential anti-competitive effects. So this decision highlights the challenge of determining antitrust liability at the time of the settlement or shortly thereafter, because many of the facts, many of the details, important details have not happened yet. They're just not known. So ex post, it turned out that the broad license that Endo provided Impacts allowed it to be the only generic supplier for many years, and in fact the only supplier altogether. The branded product, as it turns out, had to be removed from the market because the FDA had some concerns, and so Endo voluntarily withdrew its branded product, leaving Impacts as the only supplier for a number of years. So what happened, given what happened in the market for Opana ER after the settlement, it's unsurprising, I believe, that the jury was convinced that the settlement provided tangible benefits to purchasers of Opana in the form of Impacts' generic product that might not have occurred absent the settlement. So those are just a couple comments, but I hope it's come through that these are really complex cases. They're, each one presents its own sort of set of issues. And, as economists, I actually remember a lot of meetings in conference rooms where we were trying to figure out the true economics underlying very complicated fact patterns and often a lot of data. And so I've found these cases very interesting. So I'm delighted to give some economic perspective on this, but thank you very much. And I know we're a little over time, sorry, but thank you.